Hey everybody, John Skiba here from the Consumer Warrior YouTube channel, and in this video I'm going to share with you 4 ways that you can get rid of your debt collection lawsuit, win it without even going to trial. And if this is your first time here to my YouTube channel, please click subscribe, check that bell. That way you'll be notified each and every week when I put out new videos that'll help you deal with your serious debt problem. Alright, a few years ago, I put out a video about some strategies and tips and ways to win your debt collection lawsuit without having to go through the expense and the time and the stress that's related to trial. Very popular video. Well, times evolve, the law is always evolving, and so in this video, I wanted to share with you 3 reasons, and I'm actually going to throw in a 4th bonus reason or way or approach that you can use to get rid of your debt collection lawsuit without going to trial. So stay tuned to the very end to hear that bonus strategy as far as how you can get rid of your debt collection lawsuit. All right, so let's talk about the first one. The first one is by arguing the statute of limitations. Look, I know if you've been served with a debt collection lawsuit, it's keeping you up at night, you're stressed out, and the one thing though that you need to do is not be so freaked out by the whole process that you don't take action. 95% of people that get sued by a debt collector don't do anything. They don't file a written answer with the court. Now, instead of filing an answer, what you should be doing is filing a motion to dismiss if you think the statute of limitations has expired. Let me share with you and kind of explain what the statute of limitations is. The statute of limitations is the amount of time that a creditor has to file a lawsuit against you from the time that the account went into default. Now, there's a little bit of gray area, and not only that, from state to state, the amount of time that creditors have to actually file the lawsuit against you varies. For example, in Arizona, where I practice law, a creditor, a credit card company particularly, has 6 years from the time that the account goes into default to actually file the lawsuit. If they don't file that lawsuit within 6 years, they're barred forever from doing it. So what you need to see is if they have actually filed the lawsuit within the statutory time period. Now, I do have some, I'll put some notes and some links in the notes below in regards to what the different statutes of limitations are for the various states. My little disclaimer here, I don't know if they're accurate. I know the Arizona one is, but it changes often with legislatures and different rules and things like that. But at least it'll give you a kind of a place where you can start to look and do some research. Now, the difficult thing with the statute of limitations is that the creditor will often claim that that clock starts ticking at a different time to meet what I interpret to be when the law actually says it does. For example, if you talk to a creditor's attorney and say, well, when does the statute of limitations start to run? They're going to say, well, it happens at charge off. Credit card accounts are charged off 180 days after the last payment is made, so 6 months. So they're saying you stop making payments, 6 months later, the credit card company charges the debt off, and that's when the statute of limitations starts to run. However, in most jurisdictions, the courts will say that the statute of limitations starts to run when one party could sue another. Well, if you look at the terms and conditions found within your credit card member agreement, if you miss a payment after 30 days, technically they could sue you. Do they? No, they usually don't. But technically they could. And so I have always argued, and I've argued successfully, that the statute of limitations starts to run 30 days after you miss your first payment, not 6 months. That can make all the difference because it's surprising how long some of these, even original creditors, but particularly junk debt buyers, some of them will wait years to actually file their case with the court. And so if it's close, a month or 2 might be all you need. So if you find out, 1, what the statute of limitations period is in your state, 2, you need to find out when was the last time a payment was made on the card, and then you need to see if it's outside the statute of limitations. If it is, then you need to file a motion to dismiss. You can file this usually instead of an answer to the complaint, but you have to file it timely, just like you do the answer. You have to file it on time. And in my motion, I'm going to say, statute of limitations has expired. Judge, we should throw this case out. Now, if the court doesn't agree with you and they deny your motion, they will then provide you additional time to actually file an answer. The second way you can win your debt collection lawsuit without going to trial is by compelling the other side, compelling the creditor into what's called private arbitration. Now, in almost every credit card agreement, there is a term called an arbitration clause. The arbitration clause says that the parties, you and the credit card company or the junk debt buyer, if they've sold it, can elect to have your dispute resolved through private arbitration rather than going to an actual court process. Now, I often encourage people, and I do it in my own practice, instead of filing the answer, I will file a motion to compel private arbitration. Essentially, I'm telling the court, Judge, we don't want to be here in this court. I want the case to be handled in a private arbitration type setting. Now, you may be asking, what's private arbitration? It's kind of like rent a judge. These are private companies like the American Arbitration Association. The other one's called JAMS. I can't remember what that stands for right now, but it's an acronym. These are private companies that have real judges, real attorneys who act as arbitrators, and they help to resolve civil cases like this. So you may be asking yourself, John, why would it matter? If I'm in court already, why would I want to push this thing to private arbitration? I can tell you why, because there's some benefits, some strategies there. Often, particularly if it's an account that they're suing on that's under $10,000, many times they don't want to push that to private arbitration. The creditor won't, because the filing fees are astronomical for companies like that. They could literally spend thousands of dollars just in the filing fee to get the case into court or into our private arbitration. The filing fees for consumers, they're much less. Usually they're $100, couple $100, that kind of thing. And so usually what happens if you get an order compelling private arbitration, it's rare that the creditor is going to fight you there. Not only that, there are so many cases that most of these law firms that handle collections are dealing with. If you're requesting arbitration, you're taking a big old wrench and throwing it right in the gears of their machine that just kicks out all these lawsuits all day long, and it's just not something they're generally equipped to do. So it's a good way to position yourself to either get the case thrown out completely or to get some kind of low dollar settlement offer to get the case resolved. I actually have a tutorial that helps with that kind of matter. I'll put the link down in the notes, kind of shows you exactly how to do that. The third way to win your debt collection lawsuit without going to trial is settlement. Now, you may be saying, John, that's not winning. I have to pay money to settle the case, and it's true. If you're going to settle a case, you're going to have to pay something less than what it is that they're seeking to get the whole thing to go away. Now, part of this is an adjustment in thinking as far as what a win is when you go to trial. I can tell you for a lot of people, they just want this out of their life. I talk to people all day in my law practice in Arizona. They don't want to go to trial in a case like this. Even in a small case in Arizona can take up to a year. I have cases that are in Superior Court where it's more than $10,000 in dispute, where we've been going for 2 years. And so it can take a long time. It's stressful. It can be expensive. If you're representing yourself, as you're probably experiencing, if you're watching my videos, it can kind of take over your life, and it's all you're thinking about, and you go to work all day and come home and work on your case all night. Some people want nothing to do with that, and so they're like, let's just settle this and get it out. The bad side is you have to pay some money to them. The good side is you do have some control in the outcome. If you're going to trial, if you're fighting a motion for summary judgment, something like that, you're leaving it at the end. It's up to a judge or a jury to decide whether you're liable for it. That can be very unpredictable. Even in the best cases, it can be very unpredictable what a court or a jury is going to do. And so by settling it, you're taking control of the terms, you're negotiating a payment or a lump sum that works for you, and you're just getting it resolved. Settlement is not a bad way to win your case, get it out of your life, and move on with things going forward. All right, so I promise you a fourth way to deal with debt collection lawsuits without going to trial. Now, I call this the nuclear option, and it doesn't make sense for everybody, but bankruptcy is one way to get rid of that case, get it out of there, pay $0, and be done with it. Now, bankruptcy is not always a good fit for everybody's situation. It's one of those things where if someone's getting sued for $2,000 in a debt collection lawsuit, I generally don't say, hey, go file bankruptcy on that, because frankly, you're going to pay more in attorney's fees and court costs to file bankruptcy than you would just to settle that case out. However, if you're getting sued, and even if it's a small amount, if it's kind of tip of the iceberg kind of thing where there's just a ton of other debts or debt collection lawsuits or judgments, things like that, bankruptcy will blow the lawsuit out of the water. It'll get it gone. As soon as you file the bankruptcy with the court, it'll put an order in place that stops that lawsuit from going further at all. It stops. So do all other collection efforts. Phone calls, snotty letters, garnishments, foreclosures, all of that stops completely so that you don't have to deal with that going forward. So if you've kind of got a bigger debt problem and just this lawsuit is just kind of the latest symptom of a debt problem that's kind of spiraled out of control, Chapter 7 bankruptcy in particular will get rid of those debts, stop the lawsuit, and allow you to move forward. I hope that's helpful. I know, dealing with these lawsuits is very stressful. People lose sleep over it. I've always joked, I get emails and comments on my YouTube channel. They always seem to be in the middle of the night because people are stressed out and they're up worried about this. If you put together a plan, though, there are different ways to deal with it and get it in the rearview mirror. It's a civil lawsuit. It's not, there's no jail. there's nothing like that. It's at the end of the day, it's about money, and there's some good strategies to either get the case thrown out, settle it, or file bankruptcy on it and get it gone once and for good. If you're in the state of Arizona, I'd be happy to meet with you to talk about any of these options. I offer free consultations to Arizona residents. Unfortunately, I'm not licensed anywhere else, so I can't meet with other people to talk about their case, but I'll put some of the links for the tutorials and templates that I've put together that can be generally helpful down in the show notes, and I appreciate you watching today.